are listening to the Bell Post. Welcome to episode 40 of the Bell Post. Today we're going to talk about 1 year after the passage of SB 6 and how magistrating under SB 6 and all those requirements and how it's going. And today our guest is the Honorable Tamara. I'm already messed it up. Tamara Tinney. No, it is Tamara Tinney, who is a magistrate judge from Burnett County. Welcome to our show, and thank you so much for agreeing to talk to us about magistrating under SB 6.
Yeah, thank you for having me.
Talk to me just a little bit about how you became a magistrate judge.
So I was actually the clerk. I started as a clerk in a JP court here in Burnett County, and then progressed up to the first clerk ever for the Burnett County Magistrates Court. And then just moved up from there into this position when it became available. You know, clerks do that a lot with municipal courts, JP courts, and it just worked the same here. You learn a lot as a clerk and have that knowledge when it's time.
So did you start magistrating before or after the passage of SB 6?
Before.
Oh, really? How long have you been doing that before SB 6?
So it's been right over 2 years that I've been magistrating. So yeah, I had about a year, and then they said, all right, now let's change it. So.
Well, you know, I was in preparation for talking with you today. I did research the statute. You know, every state or every county that has a magistrate has a statute authorizing it. And so I pulled up the statute, and, you know, I just pulled up the government code and I just searched for Burnett County, and it pulled right up the statute authorizing Burnett County to hire a magistrate or hire magistrate judges. Now, in talking to you, I believe Burnett County has 2 part-time magistrates. Is that correct?
No. So
no.
We have 2 full-time magistrates.
Oh, 2 full-time.
Originally, it was one full-time Monday through Friday, JPs, and then Marble Falls Municipal Court would alternate weekends along with that full-time magistrate. So we would work every 6th weekend. And that's how we covered it. When SB 6 came along, the JPs and Marble Falls Municipal Judge said, look, we don't have time for this. We've got our full-time job, the amount of workload this is going to add, we just can't do it. They presented that to Commissioner's Court. So Commissioner's Court then authorized us to hire a second full-time magistrate. So I worked Monday through Friday, and then the other one works Thursday through Monday, so that our busy days are covered and weekends are covered, and we always have someone here. So it's kind of nice. We have, you know, instead of having 6 different judges in here doing things 6 different ways, we have 2, and we're in the same office, so everything kind of runs pretty smoothly.
Well, you mentioned to me when we met that SB 6 kind of tripled the time that it took to magistrate. What was it about SB 6 that caused such an increase in your time?
Well, you know, we were already looking at criminal histories. Our jail pulled them, and we had gone through class to be able to look through them. However, now even though they pull them, we still have to pull them through Ottoman, the PSRS system. But not only do you have to put in the information, put in the charges, put in the bond, check history, see if you need to let another county know that they are in jail, and then put in your terms and conditions. And then when you're done, you go back and you certify it all. And in our office, we're doing it all. So I do everything from start to finish. I don't have a clerk or the jailers doing it for us. So it's just really increased time.
So we're going to spend some time talking about that, about the process you go through, and we're going to spend a little bit more time on detail on that, because I think that's very interesting. I think there's a lot, you know, there's different approaches, and I think the approach that you're taking is probably the approach a lot of small counties take. But I want to talk about training first of all. You know, once SB 6 was passed, you know, there's several levels of training that took place, and you've already mentioned that you were already looking at criminal histories before SB 6 was passed. Was that just the county criminal history, or were you already accessing DPS records before SB 6?
DPS records, the jail pulled it, I didn't, so
Ah,
I've had to do some additional training to pull it myself now, through Ottoman, but the jail would pull it and then I could just go through it, and it was their complete criminal history from our state, other states. That was very important, I think, before SB6, without
sure.
SB6, everybody needs to be doing that. It gives you a lot of insight.
So when SB6 was passed, there were several levels of training that it required. Training on how to set bail, which that's an 8-hour training for a new judge or for a judge when it passed. And then every 4 years after that, the 2-hour training, so the recurring. And so have you been through both? I guess you've gone through the 8 hours of training.
Yes.
And what was that made of? Was it a physical class, an online class?
In person, we did it through the training system.
Well, separate apart from the 8 hours of training of setting bail, there was also, as you said, to be able to access or query the Ottoman system or the OCA system, you have to have an additional 8 hours of training regarding the DPS website. Have you
Yes,
been through that as well?
we have. So we did it in person. Marble Falls put together a class. They have someone over there who can teach the class. And so the JPs, just in case they ever need to fill in, a few of the JPs and Marble Falls Municipal Judge and myself all took the class together. Um, a lot of the class is nothing that pertains to us. And then there was a very small section that pertains to us. My understanding from one of the last trainings I went to is that they're looking at maybe narrowing that down more for us, because there was just so much that had nothing to do with what we're doing.
And would you give me an example of some of the things that were covered in the class that had nothing to do with y'all? I'm assuming just like criminal case stuff, management.
More like what the police are looking for when they're out on the road, things to look for with their driver's license and things to, and that doesn't apply to us. We just need to see the criminal history. We're not
Yeah.
necessarily entering anything, changing anything. So again, a lot of it just was not for us, which made it hard to sit there for 8 hours, but
Now, correct me if I'm wrong, but it seems like you have to go through the 8 hours of training to be able to push the button to query the system.
yes, correct.
That seems like a lot of training to be able to, I already know how to push a button.
Yes. Well, and I can understand if they don't want anybody entering something wrong. For instance, I've come across times where putting somebody's information in so that I could push that button, it tells me, oh, this person is already entered. Well, it's because somebody misspelled a name, but it has the same SID number or FBI number. And so then you end up doing corrections for other people's
I
entries
see.
like that. So I can understand it. They're trying to make sure everybody understands they need to be super careful, watch what they're doing, and don't make mistakes.
Well, I understand the 8 hours of training for the DPS website because I mean, I describe it as think of the old DOS system and you're kind of getting close to the old style system of
Right,
DPS because it has a lot of, abbreviations that you have a hard time. They're not common sense abbreviations. But
right.
I thought of it from the standpoint of you're entering data, you're querying the system, but you're also entering arrest information. And so you could be entering stuff, I guess, into the DPS website by doing that database.
I will say that I don't think that we're entering it into the DPS
Mhm.
system, but we're entering it into the OCA system, which is pulling from DPS.
Sure.
And so if I enter the name wrong, but I put the same SID number and then somebody else goes in to try to find a history and maybe they don't have the SID number. So
Mhm.
they just type the name in and they can't find anything on this person, yet this person does have a criminal history. And it's all because somebody did a little bit of a data entry.
There's two levels of training for the DPS system. There's the 8 hours and then there's a 2-hour training. Now, is it correct? Would it be a correct description to say you would have to have the 2-hour training to review, like, before SB6, the sheriff's office was printing the DPS criminal history and giving it to you. Under SB6, you'd have to have the 2-hour training to be able to review that. Would that be an accurate description?
Right.
In preparation, I like to do a lot of preparation in preparation for today. I watched a couple of training videos on the OCA website, and I thought it was interesting because they were describing the different types of bail we have in Texas, and they were describing a cash bond, a surety bond, and then they were describing a personal bond. And then they described something called a PR bond, and they were arguing there was a difference between a personal bond and a PR bond. And of course, that kind of got me interested in why are we making this distinction? Where is this coming from? And so my lawyer came out. I mean, I did some research, and I actually thought that was wrong because they were describing a PR bond as a personal recognizance bond with no monetary amount. And that used to be permitted in Texas, but when the criminal code was codified in the early 70s, it was removed. So I kind of found it interesting that they were still talking about that.
Yeah, so I know during our training with TMCC, they're always like, do not use PR bond. PR bonds do not exist. There's no such
Ah,
PR bond. It is a personal bond. And that's what we do. And you do still find, especially people who have been doing this type of work for a long time, they'll write PR and they're referring to a personal bond. But yeah, we don't do that anymore. There's always a dollar amount attached to it to where, if you don't show up, if you don't follow terms and conditions, then you are responsible for this amount.
I took a flow sheet from OCA because, again, I like to do preparation. But one of the things that they were talking about is in the flow sheet, a person's arrested and then they're processed. And part of the discussion at the legislature in the last legislative session was they're trying to help you with this time problem. And they were talking about trying to get interfaces between the Ottoman OCA system and then the local case management systems. Um, I mean, let's start with, does the jail in Burnett County and the county, the judicial system have different case management systems? So do we have one system or two system before we're going to Ottoman?
No, we all use Odyssey in Burnett County. Everybody's on the same system.
Mhm.
So that is helpful. Now, there is some type of breakdown a little bit between jail side and attorney side and case side, but we all work together and get where we need to be. But as far as them integrating this into this new system where it saves us some time, man, as soon as I heard that, I emailed like, hey, where is this? Where are we at? And Odyssey said, oh yeah, we're kind of working on that, but we're not there yet. And that has been months ago. So I pray every day when I wake up that we are almost there, because I do think if it's pulling in automatically, that will definitely start saving us some time. Then we can just double check, make sure everything pulls
Mhm.
correctly, and then go from there.
Well, and so for people listening to this and saying, what are they talking about? The time crunch or the time problem from SB6 is that you've got to, when someone's arrested, you've got to create a case in the Odyssey system, which is the local system, and then to be able to do the public safety report, you have to re-enter the information into the Odyssey or the Ottoman system. And so that repetition of work is what's causing this sponge of time. And then you can't enter or push the button to query the DPS system until it's entered a second time. What the integration would do would be allow you just to enter the information one time in Odyssey, then it would interface with the Ottoman, the OCA system, and it would pull it over hopefully with one button. And then it would do exactly what they always promised: one button, find out what their criminal history is.
Yes, that is the plan, because right now, so in our jail, the jail staff enters them into Odyssey, and then I come in and I create all my paperwork and do what I need to do in Odyssey. And then, like you said, then I have to go over to Ottoman and re-enter it and set everything up, query the system, even though I've already looked at it in Odyssey. And honestly, we have found that sometimes the criminal history that Ottoman is pulling up is not the criminal history that we're getting when our officers are pulling it. And when you ask them, there is no answer for that. So I
Oh,
always
yeah.
look at both, and then I set my bonds and I set my terms and conditions. Then I have to actually magistrate and then go back in the system to certify that I have done it and put the time that I did it, and then we're done. So it's a lot of back and forth and in and out.
When you go to the jail, I'm going to be magistrating this many people. So are you creating their Ottoman cases before they come before you? Are you doing it when they come before you?
No, we do it beforehand, because it takes some time to get them entered, and then it takes some time to look at their histories and create their paperwork. So our process is we get an email from booking every morning. They are so wonderful about sending us an email with everybody's name that we have to see. And then we can come in, we grab their folders, get everything prepared, and then we magistrate. And then we go back in to certify everything and put in the times that we saw everyone.
So that allows you to prepare all the paperwork, set up the files, allow you to review all this, prepare the public safety reports, review them, and then get organized. And then you go in and do the physical magistration. You've already said, then you have to get out and magistrate. It's kind of like you've done all this prep work to do what you actually have to do. But when you say magistrate, what are you talking about? What is it that you actually do?
So we go over criminal histories, try to set the most appropriate bond, and the least restrictive, but at the same time, depending on the crime, you sometimes you have to go higher on bond, set more restrictive terms and conditions. And if there's secondary things like ignition interlocks or scram devices or emergency protective orders, so we take care of all of that. And then in our office, we also deal with court-appointed attorneys and things of that nature.
Mm-hmm.
And during magistration, a big one right now that everybody is talking about is we also deal with mental health, see if there's anything we need to do there.
Why is mental health suddenly becoming an issue? The jails have been the largest mental health facilities in the state for some times for some of our larger counties. Why do you think now it's becoming more of an issue?
I don't know that I have the answer to that, but I can tell you that in our county, what we're trying to work on is, a lot of officers all over the place, they pick somebody up, the first place they go is the jail. The problem with that is if I have, Mr. Joe Smith and he's got severe mental health issues and he walks through that door of the jail, it becomes 100 times harder to get him in a mental health facility because the mental health facility says, well, he is now in a safe place. We need to admit, Rebecca Smith, who is on the street right now. So then Joe Smith just spins his wheels in here. A lot of times they deteriorate in here.
Mm-hmm.
So our goal, and I'm working close with our mental health officers and our LMHA, is to train the officers to realize, oh, wait, there is something wrong, and to get the mental health officers involved. So hopefully we can get those people to a mental health facility to get help before we deal with any of, the criminal charges. It's just the hospitals don't have room.
Yeah.
But we certainly have the people who need a bed.
Well, and that's a good point. I would say, first of all, you got to have the capability in your county to triage, because you got to get them in and figure out what their problem is. And I think that's a credit to your county that y'all are trying to do that. But then, like you said, the second thing is there's not a lot of places you can send them. There's not available beds. And so a lot of times the reason why the jail is the largest mental health facility, because they just don't have any room anywhere else. Some of the comments that I've heard is, when you go to a mental health facility, it doesn't have a high likelihood of success. It's low, which means there's a lot of recurrence. And so you're going to be going there multiple times before hopefully it sticks. And sometimes that's expensive.
Yeah. If they don't have insurance, and a lot of times they do have insurance, but insurance won't cover it, when they're trying to get help on their own. And so what happens is, well, even with my insurance, I can't afford it. I can't afford my medication. And so they're stuck out. And then the ones who don't have insurance, well, guess what? The hospitals can't take them, or they won't take them. It's very hard, and that's where our LMHA, Bluebonnet Trails, comes in, and they are very good at working with them, finding out if they have insurance, what they have, finding a hospital that will take them. Because it's really hard when they come in and say, hey, yeah, they need help, but insurance isn't gonna, help with it. So we've got to try to find a workaround. And they're very good at doing that. And like I said, we have 2 CIT officers right now, and they are amazing. They're mental health officers. That's their job. And they will come into the jail. They will go to a call on the street and try to also circumvent that, keep them
Sure.
from coming to the jail. And it takes teamwork for sure.
Well, and these are tragic situations. I mean, sometimes they've run through their family because, I mean, these are mental health issues and they're hard to deal with. And we have cycles of where they take their medication or they get in jail, they get on their medication, they get manageable, and then they get released, they get off their medications. I mean, it's a cycle. And so part of the triage process also gives you the ability to have leverage on them. You are going to jail, or you can get on your medications and you can get treatment. And so I think people forget that the benefit of going, there's not really a benefit from going through the criminal justice system to get mental health. But the problem is there is that leverage that you have over some people that don't want to get treatment. And it is a tragedy. There was a case where a woman was arrested that had mental health problems, and she had a bond set at $300. She refused to go to court. She pretty quickly went to the infirmary, never left, refused to see the judge, refused to go to court, refused an attorney, and ultimately died. And the county was sued. And they're like, I mean, you can imagine, we would love to have helped this woman, but she refused. And by the time she got to the infirmary, add in your comments about, well, the mental health facility, she's in a safe place.
Yeah.
We can't take her at this point. And so it's a tragedy, and it's a tragedy for everybody. It's a tragedy for the family. It's a tragedy for her. It's a tragedy for the county.
Yeah, I can't tell you how many times we get a phone call from family or friends, and they're like begging us to get them mental health help. And, the hardest thing to do is to tell them, I'm trying, but I can't at this point. But I will say again, the jail is very good. If I have somebody who's refusing and I know they have mental health, I will tell them, hey, I need medical to check them out. Bluebonnet comes in very quickly to check them out. The CIT officers come in very quickly to check them out. I have diverted many people out through our mental health officers because, with the mental health issues, I can PR bond them out, and then immediately mental health officers take possession of them. And guess what? Now they can get them in a bed because they're no longer in the jail custody.
Well, we
So,
have a lot of statutes in Texas under the Code of Criminal Procedure that says if they have mental health issues, you're required to give them a PR bond.
yes,
Probably
exactly.
the only conflict is if they're charged with an offense that's a no PR bond. So you would set a very low bond, but I mean, there's no
That,
problem with that either under the current statute.
that makes it tricky when they have some of those higher charges. And, I think that that's something we need our officers to remember too, is if they are going to charge them with a very high charge, a mental health facility is not going to take them. There are just certain charges they say no. And I think at that point it comes down to, okay, do we need to get them help and then issue a warrant to bring them back after they've gotten some treatment? Or is it really bad enough that we just need to take them straight to jail? Your LMHA will come to the jail and give them treatment, but it's still different than them going somewhere and getting it. They refuse medication here. They refuse seeing psych a lot of times. And then there's that cycle, like you said, of, well, I'm feeling better, so I don't need the medication. And then they come off of it and their mental state is not good enough to go, okay, I feel bad again, I need the medication. They just start going in a frenzy, and then it's downhill from there. To whereas you and I might be able to go, oh, look, I notice I feel bad today and I've been off my medication for a week. I should probably get back on it. So we see that a lot, and you can't make them always understand that until they're back on their medication, and then oh yeah, that was the problem.
Do you think in y'all's area, y'all see a lot of the same mental health people over and over?
Yes, we do.
I mean, what is the answer for that? I mean, this is kind of one of those questions that's just too hard. I mean, if we could solve that, we would be billionaires.
You know, I have talked to our LMHA, and I know they do it some, but I would love to have somebody that is out there going, okay, Joe Smith, Rebecca Smith, Emily Smith, they don't have a way to get to our office to have an appointment or to get medication. So guess what? Every Tuesday or once a month, we're coming to you at your house and we'll do it there. Or to come into the town and say, okay, every Tuesday at 3 p.m., we're going to be in this place. If you need your medication, we'll have it with us, and give them a chance. Because what do you do with the ones who are homeless or don't have a
Yeah.
vehicle or don't family and friends and they just can't make it to you? It's not that they don't want to. And so I don't think that's the full answer, but I think
Well,
it would be a start.
I think there are questions in this world that there's not an answer. And I think this may be one of those that the ultimate answer for the chronically mental ill people. I don't know if we certainly don't have it now. We're trying to find little stopgap solutions, but I think those problems, there is nothing that replaces family. I mean, one of my best friends, his mother had an aneurysm years and years ago, and her mental health is affected by it. And she's, I think he would say she's difficult at times because she thinks the government's always watching her. But she's married and she's in very good health otherwise. And, but when she gets off her medication, she's even a bigger handful. And so I don't know if there is a solution for those people because we really aren't into the long-term storage of mental health patients who are not going to get well. And so I don't think there is no replacement for family.
No. And people will say, well, put them in a nursing home. Well, who can afford that?
Mm-hmm.
And well, have a caretaker come in every once in a while, once a week, twice a week, whatever. Again, who can afford that? And if your insurance is going to pay for it, they're certainly probably not going to pay all of it. And so finances, I think, play a huge role in some of the mental health issues. And it's sad to see. We have a friend whose mom has Alzheimer's, and she is the caretaker of her. So it is the mom, the dad, and the adult daughter. And I see what toll it's taking on her trying to take care of her mom. And, how do you almost parent your parent at times?
Yeah.
And so then what you find, and we see it a lot in here, is the family members get tired. They get broken by dealing with it. And that mental health patient gets a little aggressive. And so then they end up in jail. And it's not necessarily because you want them in jail. It's because you can't handle it anymore. This is now taking a toll on you mentally. And I think everybody can say, well, if it was my mom, I would never. But day in and day out for years, it's gonna take a toll. And so I get that phone call too, a crying child or adult saying, I love them. I just, I had one that said, I just needed a break.
Sure.
It was her husband.
Well,
And she
I have 2 points to make on that. I have a pastor who retired in my hometown, small town. And during his retirement, he decided to start running. Well, okay, they discovered that he was having mental health issues when he started running all day. And they ultimately decided he needed to go to the nursing home. And so my dad was the one that went out and found where he was running and picked him up and took him to the nursing home. And the treatment was they sedated him. And so for the rest of his life, he didn't go run because he was sedated the rest of his life, like a zombie. And so I don't know if that's a great treatment option. But then also, this is an issue that has impacted me personally. I have a sister who had a car accident in 1989, October. I know the date. I mean, the month specifically, because it was right before I took the bar exam or right before I found out I passed the bar exam. And she broke every bone in her face in her car accident. And she had a 30-something year addiction to prescription medications after that, mental health issues that got worse over time. And at the end of her life, I was her guardian, and she was living in an assisted living facility. And she was living there just to manage her medications. She was taking so many medications a day, some to prevent seizures and all these other things, and some for depression. But the very end was probably her part of her best time in the last 30 years, because we had her medications managed. But by that time, she had lost probably contact with the rest of the family. They had, been broken, like you said. They couldn't be around her. They were just so tired. And honestly, I was one of those. And I kind of got forced into being her guardian. And then as she got better, because part of her treatment was she was just being sedated, she wouldn't wake up till noon every day. And I finally said, let's pull back this medication and see if she'll be awake more without issues. And so, of course, when she was awake more, she wanted narcotics, if she wanted me to prove it, and I wouldn't. And so she pulled off all of her toenails. But after that, we gave her a job at the assisted living facility to be like the program director, the introducer, the cheerleader for the new people, show them around. She suddenly was friends with everybody and was known as this smiling person. And she would help all of her, she would say her little old ladies, and she would take dogs for walks at the end of the day because they were too tired. And I mean, it was, I don't think anyone else would have found that result or been willing to find it, but family. And even then, family, most of the family had been just too tired, and they were no longer willing to spend time. And so I think my sister was lucky, but a lot of people are not.
Oh, but you make a good point. We have a gentleman who comes in quite frequently, and he's got mental health. And I told him one day, I said, you're walking around town all day. Why don't you help out at a food pantry or help out, here or there? And he looked at me with this strangest look, and he said, I can do that. And I said, well, of course you can. If one place says no, go to the next and find something to do with your time. And he flat out told me, I don't think I'll come see you as much if I have something to do. And that is, I think, a big part of it too, right? If we give them something to occupy their mind so that they're not just sitting there hearing or feeling whatever is going on in there that we don't understand. Is that the answer for everyone? But no, but like her, it occupied her and it gave her something to live for and be excited to do. And so
it was a distraction from all the drugs too, because she started out as a very intelligent person. So even with her brain injury that was getting worse over time, she was still smart. And so all she was thinking about, what, I need some pain medicine. I need some narcotics. And she's like, would you approve me to have some narcotics? And I'm like, no, I will not. And so, but yeah, I had to drop everything and go see her when she decided to pull off her toenails, because I told her no. But coming back, I called the facility and I said, you're going to think this is crazy, but I would like for us to come up with something for her to do. And they had a welcome committee. And so they put her on it, and it was like she blossomed overnight.
I think it's, you just have to find what works for each person. And I think a big part of it is treat them like they are a person. Don't treat them like a mental health patient. Don't treat them like someone who is IDD, but treat them like a person. And I've had inmates who, the jailers or whoever could not speak to them, but I walked in and treated them like a person, and I was able to have a conversation. And so,
I think another way of saying that is don't give up. Because it's easy to give up when you see a high failure rate and they keep coming back. It's easy to get discouraged. I've been there. And you know what? I went through a period of time over 30 years where I wouldn't have contact with my sister because the world she lived in was just too crazy. When I'm out with my family and my celebrating a daughter's birthday and I get a call from my sister saying she left a gun at some place and can I go get it? I'm like, you don't, no, quit calling me. And so,
Yeah,
I
yeah.
mean, we
It
just
was-
don't give up
Yeah,
is my probably suggestion. And it's easy to give up over time because you just go, it's just another failure.
yeah.
Well, it's kind of a long kind of rabbit trail to go down, but I think that is how important the issue of mental health is, and it's an issue that I don't know if there's a clear solution for because not giving up is not really a good solution.
No, no, it just means there's more of us working on it, but it definitely is
Yeah.
not a solution.
Well, and if I know there's one county that took some of the money from COVID and was building some mental health with some beds, but the problem is the expense for that and the number of beds they get, they're going to need a lot more than that. So, I mean, the reason why we see the jails treated as mental health facilities because that's the cheapest of all of the available options, really.
Well, and look at the other side of that too is you can't find workers right now.
Oh, yeah,
It just,
that's true.
nobody wants to do it. Nobody wants that job. Nobody, um, we're still fighting that from COVID too. I think it's everybody seems to still be struggling a little bit and getting people to come to work. So if you build it, you got to be able to staff it.
Yeah, and I've seen counties do the same thing where they've expanded their jail, but then they don't use it because they can't find workers to man it. So
Right.
it's the same problem.
Yes.
Ugh. Well, we were talking about SB6. We're talking about the kind of the overflow or the workflow that you go through where the person's arrested. And I kind of wanted to apply that to what we've talked about. So they're arrested. You got to get an email in the morning saying, hey, these are the people that have been arrested. They get processed and they're being entered into, the Tyler technology system. And then when you get your email, then you're setting them up on the Ottoman or the OCA system. And then from there, I guess once you query it and match them, then you're pulling up the public safety report or what I just say the criminal history.
Right.
And then when you say that when the workflow says it's being presented to the magistrate, you present it to yourself.
Yes.
And then after you do all that preparation and then you do all that review, then you actually go to the 15-17 hearing where you go through and you magistrate them. You just do all the different things there where you're going to give them their warnings. You're going to advise them of the conditions that may be applied, whatever those are, what their bail. You're going to talk about bail, and then you're going to decide after reviewing the public safety reports, obviously, and then you're going to decide what their bail amount is. You talked about you have to certify in the OCA system or the Ottoman system that you've done this. What does that mean? What do you actually do when you certify it?
So we have to go in and put the time that we magistrated and then certify that we did all the things, we entered the information, we made sure the information is correct. We did the terms and conditions, we set the appropriate bond, check to see if they qualified for a personal bond. And then if there was, so say they're in my county and I see that Llano County just magistrated them last week for a felony. Well, then I have to contact Llano County, that judge, and let them know. So then at the very bottom, I'm certifying I have done absolutely all of that. I have had the hearing. I have done what I'm supposed to do with this person, and I can now close that folder and move on to the next.
So does that mean you're just clicking a button that says I certification?
Yeah, it is. It's just a button at the bottom, and it has the statement that I, Tamara Tinney, certify, and I don't even remember the rest of it technically, specifically. And then you just check that box, and you cannot close out that jailing or that entry until you have done that, which is a little bit of a problem. The system's new; it was thrown at us very quickly. And so we are still finding a lot of jailings that have not been certified, because it pops up and tells us, hey, there's already an open jailing for this person, and we have to bypass that because we certainly can't certify for somebody else that they've done it. But I'm hoping that all these little kinks will get worked out. We're in the first
I'm trying to figure out and understand how that happens because, I think someone mentioned to me that if you have someone arrested, they come before you, you query the system, and you're notified, hey, there's other jailings that are open on this defendant.
right.
I mean, how does a jailing get opened and not certified?
So it would be whether it's the judge or their clerk or their jail, whoever they're having do the system, like you said, every county is kind of doing it different. They are just not ever going back and certifying that they have
So they're
finished.
doing everything but not doing the certification.
Right,
Now,
right.
if it's not being certified, is it being reported to OCA?
That is a good question. I am not sure the answer to that one. I would assume not, but I do not
Oh,
know.
well, because on the workflow that OCA puts out, then after the certification, you have the bond form. And then the bond form, the bond form is really just the physical evidence. I set this bond amount and it gets sent as you, the judge, set a bond for this amount, a bond or surety or cash or personal bond, or bond was denied. It's the result of all of this. And then that's reported to OCA and it's put on their website and it's searchable.
Right. So it makes sense then that if they're not certifying it, it's never getting sent to OCA. I am hoping that at some point OCA will come up with some type of report where they can then contact those counties and go, hey, you need to go back and address this. But again, first year they're working out all these kinks. They're
Sure,
doing
sure.
updates to the system all the time. The other thing is some of the judges are saying, I'm not, kind of like our JPs did. I don't have time for this. I'm not doing it when I'm magistrate. We've got some
Yeah,
that
but on the certification, you've done all the hard part. You've done
yeah,
everything. You've gotten the public safety report. You've done everything but check the box and push the button.
so why not do it, right? And I think it's really coming back to the training.
Mhm.
Some of these that are really hardcore, I don't want to do it. And so maybe Judge Brown has the jail doing it or his clerk doing it, and
Mhm.
maybe they haven't gone to the training. And so guess what? They don't realize they've got to go back and do that. And he doesn't care enough to check it, right? Because
Sure. He's well, or it's the old timey judges. Someone else is entering the system. Someone else is printing the reports. They're looking at it. They're setting bail, and someone else is not going back to certify this is what they did because they don't know. They don't know. Hey, what was that bond you did? I just did my part. Nobody's reporting back to me what you did, and so there's nothing for me to put in there to certify. So I can see that as well. So one of the other issues that I've kind of uh, found is on bond modifications. So the bond is originally set, and then they come back and say, well, we can't post that bond. And so we have a hearing on whether to reduce the bond. And so let's say, hey, I'm going to reduce the bond. What are y'all trained about? What do you do on the Ottoman system or the OCA system about a modification?
so I've been talking to one of our county court law clerk actually about this because we are being told one thing in training. She was told something totally different in training. So I can tell you what we were told. So we go back into that jailing and there's a place to do a modification or error correction. And then we modify whether we're changing it to personal bond or whatever, or if we're just changing the amount. And then we also can modify terms and conditions. So, maybe we're gonna lower the bond, but add the fact that they have to have a scram device if we're gonna do that. So then we can modify all of that, and then I have to recertify that I have done it at this date and time.
Sure.
And then that bill form gets sent back out to OCA.
Well, again, I listened to a video on OCA's website about it. And, they did a training video right after April 1st. And one of the things they were teaching there was, look, we really haven't gotten a handle on the modification part yet. And so check back with us.
Yes,
We're
pretty much
trying,
what I said.
yeah, we're trying to come up with, but I think later they came out with a process. And if you go to their frequently asked questions section, they do have here's the procedure for doing a modification.
Yeah.
Their current teaching is that you do not have to run a new public safety report because you've already run one. So,
Right.
but you do need to go in and, like you say, edit or create a new jailing or whatever so that you can have an event. And it looks like now they have a specific option for modification.
Right. So
And
I'll
you
just
have,
pull out that same jailing instead of creating a new one. I just pull that one up and modify it.
but what does have to be submitted is a new bond form.
Right.
Well, so I have a county I'm looking at, and I'm not trying to put anybody in the spotlight, but I found a person who was arrested for murder, $350,000 bond. Okay, didn't get out of jail, so it was modified to 150,000, and then it was modified to 50,000, and then it was modified to 10,000 and granted a PR bond. Now, then a couple of weeks later, they were arrested again, and then they were changed to a no bond. The only things reported to OCA was the $350,000 bond and the no bond. None of the modifications were reported to OCA.
Yeah.
And I think this is a systemic problem for that county where they're not reporting modifications. And some people's like, well, why do you care? Well, wait a minute, we're reporting data to OCA so we can figure out so we can rely upon this data. And here's one example where the data you're looking at is just not going to be accurate if you're not looking at modifications.
Well, I know that, so for us, for instance, if I set bond and it's a murder case, and then the district judge comes in and says, I'm going to lower it, or I'm going to change terms and conditions, it won't be me who goes in there and modifies it. It would
Sure.
be his clerk or himself, however they have it set up. And I don't think, like you said, that kind of come back to us. Nobody knew in the beginning. And so for us, the other courts were like, well, how are we even going to access your stuff? You did it in your court. Well, then they made it to where you can just search a name, pull it up,
Sure.
and even though I did it, they can modify it. But none of that was said in the beginning. It was just, hey, do this.
Sure.
No explanation of how to do it. Kind of like me saying, go replace your roof.
Well, okay, so let's in a better light, we would say when OCA did their original training, when everything went into effect in April 1st, they didn't have a process for modifications, and they've since come up with one. And so we're hopefully we just have a time lag, because I would hate for some judges to be interpreting this as, oh, I don't have to do modifications.
Right.
We want our data to be accurate. We don't want the legislature to go back and further look over our shoulders and say, specifically, you've got to do a bond form for when you set bail or when you do a modification. OCA teaches you have to do you have to report a bond form for a modification. And that, I don't think anybody is saying you should not or don't have to. So we just got to get that trained and get that being done.
I think this came out so fast. Talk about a fastball right in our faces, because it was, well, we'll have it ready. We'll have it ready. Oh, it's going to be ready, and you're going to do it in a month. And I think there was a lot of us, including me, that were like, it'll be delayed again. But
Yeah.
it wasn't. It just came out with a whole lot of bugs. And so, I think that there is a huge lag. I think that there is also those judges who have not done the training that are relying on clerks or jailers, which is totally fine to do the data entry, but maybe they haven't had their training. There's a lot of bits and pieces that I think still need to finish coming together. And so I think, just like anything new, over time, it will all work out. But just that time frame of getting it done.
In the process of SB 6 being passed, one of the things that kind of has grown after, or is the result of SB 6, and I don't think anyone even thought about it, was this whole issue of a warrant being issued based on a probable cause affidavit. And then suddenly we have this requirement that when you set bail, you have to review the public safety report because you have to review the criminal histories. And then suddenly we have, okay, I've issued a warrant based on a probable cause affidavit, and I've set a $5,000 bond. And then, or we have a grand jury who issues a warrant and sets a $250,000 bond. And it's been very difficult for the system to look at that warrant or that arrest and say, okay, is that warrant, is that bond amount a suggestion, or is it mandatory? And how do you, as you're sitting in your office preparing, how do you tell the difference between those two?
So if it's a no bond, then that's usually a motion to revoke, something like that. And that's pretty standard, right? It's like, okay, we've got to get you in here. Everything else is a recommendation. You're actually not allowed to, a magistrate gets to set bond. You can send me warrants all day long with recommendations on them. I don't have to choose them. Are you going to get mad at me? Most likely, but it's still my choice. The
But
way
does
I
the system show that the warrant, I mean, if a warrant was issued by the grand jury, that can't be changed by a judge. And so does the system show that that was a warrant issued by a grand jury?
So it does in our
Okay.
county. Don't
Ah,
know about others. Our county does. But as far as warrants from, other judges, just, hey, Officer Joe brought me this PC. Those are recommendations. And I kind of look at them like, okay, you had the information about the charge, and I don't, because I don't always get anything but the warrant. So I take the recommendation into,
sure.
consideration. And I will say generally we end up going with them. However, I've had times where, okay, he came in on your warrant plus 5 new charges. Guess what? I'm probably going to bump your
Oh,
bond
sure.
because now we have reason to do so. But yeah,
House Bill 1318, which was considered in the last session, it didn't pass at the very last moment. We anticipate it'll be on a special session, maybe in October. We just don't know. But it had a proposal for the warrant situation. And the proposal there was to allow judges to review a public safety report before issuing a warrant with a bond amount. And it was discretionary. And so I was kind of concerned about whether that was an actual fix. I would prefer the statute to say, if you're going to propose a bond amount with a warrant, you have to review the public safety report. Then it's not discretionary and then you could do walkthroughs, which would speed up the process. But what is your thoughts about, those proposed fixes?
I think that anytime you're going to issue a warrant, it is a good idea and should be mandatory to look at the criminal history. You may say, well, I've known him, he's lived here almost all of his life, or I've dealt with him in the jail a few times. But you don't know that last week he went over, to Lampasas and had his third DWI. But right now you think it's just his second. And so you're, lowering, because that happens. Sometimes officers bring in and they don't charge the highest and you don't know. So I think it's good to review it and see what's been going on that you don't know about in that person's life.
Sure. Well, I do agree with what you said that, the judge issuing the warrant, it's really, a lot of times it's their case. It's going to come back to them. And so you're going to consider their recommendation because it's in essence their case.
Right.
But it would simplify the system. We wouldn't have this whole argument. I mean, who would have ever dreamed in SB6 that we'd be having an argument about whether a warrant was discretionary or a recommendation or mandatory? I mean, that wasn't part of SB6.
Right. They tried to cover the bases, but there's no matter what you do, there's always it leads into something else and
Well,
something
and I
else.
think that's the whole point of this what we're talking about is the unintended consequences when you make changes in an area of the law, because the changes that were made, and I would say the number one change of SB6 was the importance is requiring the review of criminal histories before setting bail. I think that's the biggest change, and it's a great change. We all agree we should be reviewing criminal histories, and I even think the voters would say we're not doing that already.
Yeah.
So I think, but I can see the judges going, well, no, the biggest change to me was all this training and all this paperwork I have to do.
Yeah, because a lot of us were already looking at criminal
Sure.
history.
Mm-hmm.
I mean, I hesitate to say it, but a lot of us were already doing it right and
Yes.
reviewing criminal
Well, and we
history.
had case law at the time that said you could review criminal histories. It's just, it wasn't mandatory and it didn't have it in the statute. It just said other considerations but there was case law that said you had the discretion to review criminal history. So I agree with, as you said, there's a lot of people that were doing it right and some did not, which was the result or the cause of SB6.
Yes.
One of the other things that House Bill 1318 was seeking to address was adding some additional offenses to the no personal bond list. And What are your thoughts about this whole concept of we're limiting the use of personal bonds as a result of SB6?
Honestly, most of the charges that they consider to be no personal bonds to me are kind of no brainers. I mean, I'm not
Mhm.
going to personal bond a murder. I'm not going to personal bond human trafficking. I'm not going to personal bond a sex offense. So I think that unfortunately it's necessary to lay those out there and say, hey, you can't do this. But I don't think that um, there's really anything being thrown in there that we shouldn't have already been considering no personal bond anyway. Now, if it gets filed and it's in district court and the district judge says, okay, now it's time to do that, that's his deal. But when they're first coming into jail, when we're first trying to, well, not we, but the officers are first trying to figure out what just happened, I don't think that's the time for them on those certain charges already.
Well, and that's kind of been my position as I've talked across the state is the majority of those offenses were offenses that never would have been granted a personal bond across the state. I mean, we're having to put this in statute because of one or two counties that are trying to uh, change course with a political agenda, maybe, and I think that's driving our it's driving policy now. And for the vast majority of the state, those changes don't reflect anything over what was already being done.
Right. And all they're doing is really creating more work for themselves because they were the ones not doing it in the first place. And now they're being told you have to.
Well,
And it's created more work for the rest of us as far as entering in the system and everything else. But the generalized part of it is, yeah, we were already doing that stuff.
when someone comes before you, I mean, I always say that the criminal justice system, we treat a first time offender differently because we want to impose the smallest amount of pressure to get you to turn around. And then as you go through the system more times on your way to a career criminal, where we decide that you're not going to be turned, you need to go to the prison. I mean, each time we want to put more pressure to try to cause you to change your course of action. Um, but then we have this whole in our urban areas now where we have just the sheer number of people being arrested. We just want to treat everybody the same, whether as long as they're being arrested on the same offense, no matter how many times. And my criticism of that, when you tie the hands of you, the judges, the magistrates, to protect the poor, that's the reason why we say we're doing it. Well, then we can't address organized crime. We can't address gang members. We can't address career criminals. And so even with good intentions, some of the unintended consequences, you can't address the entrenched criminal elements if that's what we're doing.
I think that you're exactly right. And does somebody's financial state need to be considered? Absolutely. But also their crime and their criminal history. Like you said, if I have a first time person coming in for stealing and it's, class B theft and least restrictive, come on now. Hopefully a night in jail was enough for you. Go on. If I see her in another 2 weeks and if I see her then it starts becoming a problem. And obviously getting a low bond or a personal bond didn't get anywhere. It's the same thing as when you're getting onto your child. If you say, I'm gonna, ground you for a day and you can't ride your bike, and they learn from that, great. But if they're, the first day they get their bike out, out causing havoc again, you got to get a little tougher on them. And it's the same thing. And unfortunately, what you find is a lot of the criminals aren't working, but they don't have money, but it's because they're not working. They're out getting in trouble. So one of my terms and conditions is always maintain or seek employment.
Sure.
If they're retired, I say find some volunteer work to do. idle hands. You're just going to get yourself in more trouble. Keep yourself occupied. It should all be everything just looked at in a whole. But again, like you said, there's the group that does it. There was the group who didn't do it, or they did one extreme or the other. And so now here we are, and our hands are getting tied. And so then you have, well, you let this person out on too low of a bond. Well, I had to because the law says this, or you gave them too high of a bond. They can't afford it. Okay, but the law says this. So at some point, you have to let us do our job. But again, the problem is you got the group that isn't. It's like everything else.
Well, but once you have a criminal history, that trumps everything.
Yeah.
If you can't afford a bond and you have a criminal history, you're not in jail because you're poor. You're in jail because you have a criminal history.
Exactly. I would agree with that.
One of the things we've not talked about is what impact is illegal drugs having on this, the crime problem that we're currently having? Is it one of the driving forces?
I would say so, because, even the person who comes in for a theft, there's usually some, not always, but usually some kind of drug history. That people are coming in for criminal trespass. It's usually involved somewhere, somehow.
I read a book one time that said if we give up on drugs as crimes like they did in Portland, you're giving up on crime, because 80% of all crime somehow is an offshoot of illegal drug trade.
And you're right. And it goes back to the mental health issue too, because what do the mental health people do when they cannot control it anymore, and they don't realize they need the medication, can't get the medication? Well, they turn to substances to take care of that mental health, or I get so tired of hearing, well, they don't have mental health, they're just a drug abuser. Okay, well, drug use can cause cause mental health. It goes hand in hand. If somebody uses long enough, guess what? They're going to end up with some mental health problems, most likely. Drugs are involved in every part of the system. And, yes, you have those that have never used and they're still criminals, but I would say, yeah, probably 80% of them are.
But to me, the importance of the criminal justice system for the drugs that, the illegal drug trade is, we're the hammer that can force people to go get treatment.
Yes.
We'll offer you treatment, and maybe we'll have a 25% success rate. So maybe you have to go a couple of times, but we are the hammer that gets them there. And otherwise you go to jail. If it's like Portland, where they say, oh, we're going to decriminalize heavy drugs, but we're going to offer all this training, all these services. Well, what happens? 0.01%, less than that, elect to go to services, and they're having a record number of overdoses every month. I mean, that's not a viable solution in my mind. That's a bad solution. That's terrible.
It's like if you had any crime and you said, well, it's okay, guess what's going to happen? It's going to get worse, right?
Sure. Well, then, we've talked about magistration, and we're really kind of trying to figure out a way to get people released from jail as long as they promise, because the purpose of bail, no matter what kind it is to get them to come back. I mean, it's, there was a dark time, where you could just get released and then run. If you were here illegally, you could go to Mexico and you don't ever come back, as long as, I mean, that's still true today. If you are a national of Mexico and you commit a crime here, you get out and run to Mexico, they won't deport you.
Right.
And so, I mean,
like flying out there,
yeah. Yeah,
but
the police in Mexico won't help deport somebody who is a national from Mexico. We see that all the time. And so, so the purpose of release is to get people to come back and to address their criminal charges. And the trouble that I see is, after we get through magistration, the type of release, we've seen a lot of the impact of the type of release on steroids because of COVID. You see, simple release, whether you call it a personal bond or whether you call it a no bond, like in LA, or you call it a zero bail, or you call it a release on no bond, like in New York. A simple release has a much higher failure to appear rate. And so we have this dichotomy where we're saying, well, we've got to release this, everybody who caused this crime or committed this crime, no matter how many times we got to treat them all the same. And that just seems contrary to the history of our criminal justice system. Once you review criminal histories, that should all be out the door.
I agree. Because I have people all the time, as you can imagine, say, can I have a personal bond? Well, a personal bond is me thinking and saying, I believe that if I let you walk out that door with a few terms and conditions to follow, that you're going to show up, that you're going to do all the terms and conditions, that when you get a letter, you will be at court, and that you will follow all their, terms and conditions. And I can't say that if I'm looking at a long criminal history, and especially if I'm looking at a criminal history that shows you failed to appear, you had an MTR, you SRA. Well, then how am I going to say that and sign my name saying that I believe you're going to show up?
When you release somebody on a personal bond in that situation, you're saying the bondsman does nothing. The private industry does nothing. And that is just not true when they're reporting and we're reminding them of their court dates, because really these are problem children. And so they need to be reminded of their court dates. And it's not a situation like you hear in Harris County, well, we'll just give them a free cell phone and we'll text them. Well, they're problem children. They're not going to keep a cell phone. They're going to go sell the cell phone to buy drugs, or they're going to lose it, or they're going to break it when they lose their temper. So what we found is that, they've lost it so many times, or they've thrown it away or whatever. And so that didn't work. You've got to get family involvement in, and you've got to keep getting contact with them. I mean, the more contact you have, the more trust they have in their bondsman. And then we can remind them to go to the court date, or we can go pick them up and go take them to court. And then, in our urban areas, I think the biggest thing that gets lost is once someone fails to appear, the really test is, do you care? Do you care if they come to court? Because, in Harris County right now, with the 80% failure to appear rate on misdemeanors where they don't do anything to them, you can't get cases resolved. But if you care that they come to court, you want the private industry involved, because they're the only segment on this system that can go get them and bring them back. Everyone else, we're issuing a warrant. The warrant goes down the hall to join the other warrants waiting to be served. In our urban areas, that can be tens of thousands of warrants waiting. So that means they have to commit another crime to come back into the system. And so I think all of that gets lost. And there was a town hall meeting recently that News Nation did, and they invited mayors from across the country in urban areas. And there was a very Democratic mayor who stepped up and said, what we're doing is not working. And until we find an alternative to the private industry that has accountability, that has the same similar amount of results on appearances, then we don't have an alternative. We have to keep using the private industry. And I thought, whoa, we've really got to a new day when Democrats are starting to recognize, and now even we've had the NAACP in Oakland issue a letter attacking their local public officials for crime, demanding that we have a state of emergency on crime. So you start to see things change where, even the left is saying what we're doing is not working. And that, I think that's a big change.
Several years ago, legislature was personal bond, personal bond, personal bond, personal bond. And then 2 years later, when they met back again, they were like, whoa, wait, higher bonds, higher bonds, higher bonds. And it's like they're looking for a cookie cutter answer, and there is not one.
Yeah, that's right. That's right.
That's why you have me, and that's why you have the other magistrates, is because you gave us the job to look at all of this and put it together and find the best answer per person, individual. I can't set bond across the board. It states that I shall do it individually, that I shall look at each person. And yet they're telling us in a way like, no, you're going to do it just like this on everybody. And I know that there are those bad apples that are the reason for all of this coming about. But you know what? There are those bad apples in every career there is. I think you weed those bad apples out and, let the others do their job. I can't look at you the same as the next person or the next person. It just, everyone is different, and their criminal history is different, their circumstances are different, and the probable cause and complaint is different. You could have two theft charges that are both class B's, but be completely different circumstances that would lead to completely different bonds.
Well, I look at what we've talked about today. The comment that sticks out the most is, as you said, there's people that have been doing the right thing all along, and y'all are going through the system, and SB6 is really confirming, although it's adding a lot more procedure, it's a lot more time, that y'all were doing the right thing, and you have continued to do the right thing, fitting into and complying with all these procedures that have to be done. And so, I thank you for that. That's, you got to be going, why am I having to spend all this time when I was already doing it right? But
Yeah, there are those days.
well, thank you so much for talking with us and lending us your expertise and your knowledge about SB6. I think, I've been doing this for a couple of years, and I would have never dreamed that I would learn SB6 to the detail I had. I talked to somebody about it, and he's like, "Ooh, you actually know a lot more about it than a lot of judges." And I'm like, I didn't intend to.
You're doing good, because I hear what is SB6, and I'm like, oh my gosh. Okay, let's sit down and talk. So,
Well, thank you so much for being our guest today. It's been a great conversation, and hopefully some of the judges in the state will find this helpful to them, and they can improve their procedures in implementing SB6 and in doing magistrations. Thank you very much.
thank you.
Thank you for listening, and come back for the next episode of The Bell Post.